Good morning, everyone, or good evening, and welcome to today's webinar on the changes affecting international students. I'm Kalpana Pedibotla, and I'm the Executive Director of the South Asian American Justice Collaborative, or SAJCO. So SAJCO grew out of a vision many of us had for years, which was to build the first national civil rights organization dedicated to South Asian communities in the United States, much like other communities who have built national legal organizations to protect their rights. Our mission is to fight for the civil and human rights of the South Asian diaspora through legal advocacy, community engagement, and narrative change. International students have been an important part of that work from our earliest days. Last spring, when international students across the country began having their immigration records and status abruptly terminated, we worked to help students understand and protect their rights, including participating in a hotline set up by the UAW 4811 for academic workers in the University of California. So when these latest changes affecting international students were announced, we knew this was an issue where we wanted to help provide clear, reliable information about what the changes actually mean and what students should be thinking about. We're so very grateful to be doing that today with our partners at the South Asian Bar Association of North America Foundation, which actually incubated SAJCO before our independent launch, and the South Asian Bar Association of North America, the national organization representing South Asian legal professionals. We are also very grateful to the Murthy law firm for partnering with us and bringing its immigration expertise to today's discussion. Today's program will be moderated by Mala Bajpai, who serves in leadership roles with both SABA North America and the SABA North America Foundation, and is herself an experienced immigration attorney whose practice includes business and family immigration and representation of international students. Mala, thank you so much for being here. I'm going to turn it over to you to introduce our guests and get us started, and I will be exiting the webinar to join you all as a guest. Thank you so much.
Thank you so much, Kalpana. Definitely when we heard about this rule change in July and before that, it was definitely a natural alignment of all of our organizations to really come together to co-present this important issue. It's my honor to represent SABA North America and their immigration section and continue this webinar as part of our Immigration Chai Chat series. Today, we have two experts to help us kind of dispel a lot of the anxiety surrounding the new rules. I'd love to introduce Tejas Shah, who is representing the SABA Foundation, as well as a co-founder of SAJCO. He's a partner at Barnes & Thornburg in Chicago and represents Institutes of Higher Education, Students Advisory Services. Thank you so much for joining us, Tejas.
Thank you.
Also, we have Anna Stepanova from the Murthy law firm, where she's the co-managing attorney representing employment-based and family-based immigration issues. She's a renowned author and public speaker on immigration issues, and she has one quality that most of us immigration attorneys do not have. She is a former DSO, which makes her uniquely qualified for our webinar today. We just wanted to lay out a roadmap on our next slide of the things that we're going to be discussing today. And I have to say, this just all hits very close to home as I moved my child into college last week. And I can't imagine being on the other side of the world, having sent my baby across the world and seeing the headlines in the news about their status expiring. So we're really here today to really dispel a lot of the anxiety and then really just highlight the changes and answer a lot of questions that are coming up. So with that in mind, and before we get started, there's also want to make sure that nothing in this webinar should be construed as legal advice. Everybody has unique circumstances, situations are unique to employers and students, so please seek out your own consultation and immigration advice. This is just a high-level roadmap of the changes that we're expecting to see. And with that, I would like to turn it over to Anna. get us started
Thank
on
you.
what's a change.
Thank you, Mala, and thank you for the introduction. So we also have questions, and everybody has questions about the new rule. It's vast, and there are things that it changed, and there are things that it didn't change. So we'll parse it out carefully today, and hopefully will help people kind of figure out what the main points are, what they need to consider. The rule states that an effective date that it will go into effect is September 15th. But because DHS classified it as a major rule subject to congressional review, there's still time for something to happen between now and September 15th. So it can be changed by a congressional action, it can be changed by the DHS itself, or it can be changed as a result of an ongoing lawsuit that was filed just 1 week ago on August 18th by NAFSA and Coalition of Higher Education Associations and labor unions. So from what we understand, the government has until August 31st to respond to the complaint, and the first hearing is set for September 3rd. So we're watching it very closely, and as soon as we know something that happened in the lawsuit that may change the outcome of the scheduled September 15th start date, or the rule itself, any provisions in the rule, then we will post it on our website, murthy.com, and we'll share it with our colleagues and the general public. So with that, what are we going to talk about today? First, the fixed period of admission. That's everybody. That's something that everybody is talking about. Now, there are two clocks to track now. It's no longer enough to have a current I-20 and to make a normal progress toward completion of one's degree. Now, people would have also to track the I-94 admit until date, AUD. So we all have to get very comfortable with this new acronym, AUD, that puts the F1 category kind of in line with the rest of most of, not all, but most of the non-immigrant categories that already have a date-specific end date of their I-94. We'll also talk about shorter grace periods, the transition protection. So the rule carves out some transition rules for students who are already here. And we'll talk about some trigger points and some key considerations. You know, what is going to happen when someone needs more time in the U.S. If they plan international travel, if they change their schools or majors or programs, can they do it? Can they not do it? How the rule is going to apply, and what are the exceptions? And what are the exceptions based on extenuating circumstances? How the rule defines what they are. And then finally, we're going to talk about practical training and some takeaways that hopefully will help people kind of navigate this complex landscape of the changing reality that we have to deal with at this point.
Thank you, Anna. Can we get the next slide up so we can dive into the changes?
All right. So what is changing? As I already mentioned in the previous slide, under the current system, as we're all familiar with, most F1 students are admitted for duration of status, right? So that is commonly shown on the form I-94 as D/S. But under the new system, students will generally be admitted with a date-specific end date, AUD, and admit until date, that is shown on their I-94. And the I-94 is going to become kind of a critical immigration document along with the Form I-20 that we're all familiar with, and the students are very familiar with, because the I-94 is going to control how long the Department of Homeland Security has authorized that student to remain in the US. Okay, so the I-20 still remains to be very critical and important and essential, but a valid I-20 does not automatically extend an expiring I-94. So you kind of have to now look at both. And the central compliance question will be kind of twofold. First, is the student maintaining all F1 requirements as we know them? And secondly, is the student's current I-94 still valid? So both of them will have to be assessed separately and together. So both of them are going to be critical for the student's ability to continue staying, living, and studying in the US.
And just so we back it up a little bit first, because this is mainly going out to students, what happens if there's two different dates on the I-20 and I-94? What
And
should
this is something that's a very good question. So I think that we're going to give a few examples later in the presentation, but just kind of to illustrate this point, you can have an I-20 that is for a longer duration than your I-94, then you would typically have to apply for an extension with USCIS.
Let's jump to our
If
next slide. I think that does highlight what you're saying.
Okay.
Okay, sorry. Go ahead.
All right. So two clocks to track, right? As we discussed in the previous slide, I-20 plus CVIS. So this is something that we're familiar with, which is going to continue, just like it's been working before, right? So the CVIS and the I are going to reflect the program end date. The enrollment on a full-time basis is still a requirement. And all of the program extensions, transfers, changes of level, recommendations for OPT, STEM OPT, CPT, authorizations, all of the DSO actions that we're familiar with, they're still going to happen, okay? And now switching to, or in parallel, kind of looking at the immigration clock, the I-94 clock, this is the expiration of status, okay? So that may be different from the expiration of the I-20 or the expiration of the OPT EAD. So the DSO may extend the I-20 in CVIS, but there will need to be a separate action to extend I-94 by either travel or applying for an extension of status with USCIS. So the question now is whether the student has been maintaining F1 requirements and whether the I-94 is still valid and what needs to be done to keep all of them valid and current and in compliance with the new rules. So that is going to add to the to the requirements that we've had so far since 1979, when the D/S became the general rule. So now we're changing it, in many years. So this is going to be different, and we all have to be ready for it. I also wanted to make another point, which is important. We shouldn't forget about the dependents. So it's really important that F2 dependents, spouses and children, they will have to take care of their own I-94s. So that reminds me a little bit about, dependent on H4, very common problem when H4 spouses or children are not extending their status, assuming that their status is extended because their H1B spouses or parents' I-94 is extended. So we're probably going to have the same issue with F2s. They will need to take care of their own extensions, and they're individually responsible for maintaining their status based on the I-94, which is going to be separately issued to them.
Thank you, Anna. Can we have our next slide up? Tejas, can you address some of the misconceptions that we have about the AUD?
Yeah, absolutely. And thanks so much, Mala. And really happy to be here on behalf of the SABA North America Foundation. Real quick, only because we saw a couple of questions on this, I wanted to sort of proactively mention, I know that we have a decent number of folks in J1 status who are wondering whether we're going to speak to J1 related issues here. Much of our focus is going to be on F1s, but I also want to note that the concepts that we're talking about are going to be transferable to J1s. Just substitute DS 2019 in place of I-20, if you want to understand how the guidelines apply to you. In other words, whereas in the past with the J1, you might have been able to look at the DS 2019 program end date as sort of the determinant of how long you can stay. Your I-94 would say D/S. If this new rule goes into effect, then similar to what we're talking about with F1s, you're going to have to look at your I-94 and the sort of shorter of the I-94 versus the DS 2019 is really going to apply. With that, let me try to answer your question, Mala. So the short answer is no, 4 years is not a maximum limit. That is a misconception about this new rule. But what they're basically doing through this new rule is they're basically saying that, look, if you want to extend your F1 status beyond 4 years, then you're going to have to apply for permission from the immigration agency. The purpose of this new rule is basically to say that it is insufficient for a DSO or a university or college to make the determination that your status should be extended or that that your program duration should be extended. They're basically saying, well, we want to have an opportunity to review, your maintenance of status and the reasons you want to extend your stay in the United States, through this form I-539. And one of the biggest impacts of that is or one of the biggest legal issues there is really this question of non-immigrant intent. When you're here as an F1, you have to be able to demonstrate that you have the intention to reside or to eventually return home. Typically, that tends to be an issue, when you apply initially for that F1 visa at a consulate the first time you're moving to the US on a student visa. Sometimes it comes up when you go back to visit family if your visa is expiring and you need to renew it. But it's not typically an issue that comes up, when a DSO or university is making a decision about whether to extend your program duration. But now with the requirement to file an I-539 with USCIS to extend your F1 status, you need to be aware that that is going to be a more relevant issue that USCIS can look at. Um, Getting back to the question of the 4 year duration, I also want to mention that it is not an automatic given that everyone's going to get 4 years. It's the shorter of 4 years or the program duration. So, for example, if you sign up for a language program or an associate's degree, or you're attending a community college, you may be looking at a 2 year duration on your I-94. You'll note also, if you're familiar with F1 rules, that F1s who graduate within 4 years are then eligible to stay on for at least an additional year if they've graduated in good standing, and are maintaining status so that they can apply for the OPT portion of their status. And if they graduate with a STEM degree, then they can further extend for 2 years under certain circumstances for STEM OPT. Now, in the past, you would have had to only file an I-765 or work authorization request with the immigration agency to get OPT and STEM OPT. Now you're going to have to combine that with an I-539 as well. The one other thing I want to quickly mention here is for individuals who are traveling, just make sure you're checking your I-94 every time you travel in and out of the US. Because while your I-94 could be, valid for that initial 4 year period that we mentioned, there are times where the I-94 could be shortened even further if you have a passport that's expiring earlier than that 4 year period. So we're probably going to talk about that a little bit more as we continue with the program, but I did want to make sure that folks are thinking about that as well.
Yeah, I think it's a really good point that you mentioned that it's not an automatic 4 year period on your I-94. Let's go to the next slide. They
Yeah,
just what? Maybe you could explain firstly what the grace period is before we get into like the changing.
Yeah, absolutely. So the grace period is a period after you complete your authorized course of study. For example, if you're doing a bachelor's program, after you've completed your bachelor's degree program, you've received that diploma. The grace period is typically considered a period that, you're allowed to use to sort of transition to a different status, or you might be able to use that grace period to apply for OPT. Or if you've decided that you're going to enroll in a new educational program, you can transfer into a new educational program during that 60-day grace period, or convert to a different status, or potentially depart from the United States, sort of, use that last 60-day period, to travel, visit friends, visit family before returning to your home country. So under this new rule, that 60-day grace period is now being shortened to 30 days. Now, that doesn't necessarily mean that somebody who's in an F1 status in the United States right now is going to have a 30-day grace period. We're going to talk a little bit about the transitional rules as we continue this webinar. But for individuals who either become subject to this new F1 regulation as a result of traveling outside the United States and returning on or after the effective date of this regulation, or they enter on an F1 for the first time after the effective date of this regulation, you may have a 30-day grace period instead of a 60-day grace period at the conclusion of your program. And one particular thing that I want to note here, as you dive into the weeds of this new regulation, is that there are certain benefits that you can obtain even if you have a pending extension of your F1 status, so long as you file that extension request before the end of your program, before your grace period starts. But if you file that I-539 to extend your F1 status during your grace period, you may not get the same benefits. And so there, what I'm referring to is sort of akin, for those who practice immigration law, there's this concept of a 240-day period, right? If you're in a work authorized status, you apply to extend that, you apply to extend that status. If the immigration agency is taking a very long time to act on that application, you can be authorized to continue working even after your status expires for up to 240 days while waiting for the immigration agency to act on that application. There's a similar concept here for the F1 extension of status in the regulation, but it only applies if that extension request has been filed before you transition into the grace period. So if you're going to become subject to the grace period, the new grace period, or you're going to be subject to the requirement to file an extension request, I'd strongly recommend that you ensure that you've educated yourself, maybe had a conversation with the DSO at your university about the consequence of getting that extension request on file at different points in time.
I wanted to add just one point, just going back to how the 4-year maximum period is calculated. So with regard to the 30-day now grace period, the reduced grace period, it doesn't, it's not part of the calculation of the 4-year period maximum that is going, that CBP or USCIS can issue an I-94 for. So that's going to be 4 years plus 30 days. For new incoming students, also, just like before, they can come in up to 30 days before the program start date. So it's not exactly, a grace period, but with regard to how to calculate the maximum of the 4-year period, the 30 days program, the start of the program, and 30 days of the grace period, they're not calculated in the overall 4-year maximum. So they're added to it, and that is an important also. When you try to see if what I-94 you're going to get, for a particular program. So that becomes a little bit of a math, kind of exercise. But I think that's helpful to know that the 4-year maximum, has an add-on in the beginning and at the end,
Which,
potentially.
yeah, that highlights your last slide about having the I-94 expiration date as well as the I-20 expiration to watching both clocks, because the extra 30 days will be added on to your I-94, not your program date. Okay. Our next slide.
Yeah, so let's talk a little bit about transition protection. So, obviously there's a whole slew of individuals, I'm sure many folks on this webinar right now, who are already in the United States in F1 status. And you're probably wondering, hey, does this new rule impact me immediately? What's the impact? So you're falling into what's going to be called a transitional group, is referred to as a transitional group under the new regulation. And so if you look at your I-94, it would indicate that you were admitted for duration of status. That I-94 does not automatically get converted to a fixed end date. It's not like CBP is going back and retroactively converting all these I-94s, to reflect the new rule. So if you have an I-94, based on previous admission to the United States that reflects duration of status, you are maintaining valid F1 status as of the rules implementation date, which again is September 15th, and you are physically in the United States on September 15th, then you are eligible for what we call these transitional protections. Now, what is the significance of those transitional protections? Well, they're temporary. You need to know that first and foremost, right? It doesn't mean that you can effectively spend the rest of your life in F1 status and benefit from the pre-existing rule. There's an end date to those transitional protections. The end date is either if you travel outside the United States on or after September 15th, when you return to the US, you will be readmitted with a fixed end date, or AUD, on your I-94. So at that point, you're now subject to the new rule. So for any F1s, and it's a very common occurrence for many F1s to go back home either over the Christmas holiday or summer holiday to visit family, just be aware that that travel, if this rule does go into effect as of September 15th, is going to trigger this new set of rules. And as Anna mentioned earlier and Mala mentioned earlier, it is critically important that you pull your I-94 once you're readmitted so you can start tracking that end date along with your I-20 end date. If you do not travel outside the United States, well, you potentially lose the transitional protections. The latest that the transitional protections can apply to you is effectively 4 years and 60 days from the implementation date of this rule. So that basically translates to November 14th of 2030. And that 4 year and 60-day period accounts for the sort of maximum time period that an individual could otherwise be admitted for, plus the 60-day grace period. So
Grandfathered in, the 60-day grace period grandfathered in, right?
Exactly. So that's where that November 14th, 2030 date comes from. So it's going to be very, very important that you're aware of sort of when, how travel impacts your transitional protections. And if you don't travel, be aware that, there would be an end to the sort of duration of status treatment of your admission to the US.
I think a very important point that you're making, 14 to 30 date, I think it's just it's worth reminding people that this is not exactly what they're getting with, their it's not even like grandfathering, but the transition benefits, but it's the maximum that they can get. So, for example, somebody who has an I-24, a PhD program that is going to last beyond November 14, 2030, and they don't leave the US, then they're going to get up until November 14, 2030. But program lasts, is for a shorter duration. For example, if their I-20 is going to expire in 2029, say, then they only have until 2029. They will have to apply for an extension if they need more time after that. So the November 14, 2030 end date is the absolute maximum. So just wanted to make sure that people understand that, because it's not really self-evident, when you're looking at your I-94 with the D/S designation, whether, what is the end date that I should consider my status, the end date for my status based on this D/S I-94. Well, it's the end of your program plus 60 days or up to November 14, 2030, whichever comes first, right? So I just wanted to make sure that, people don't overlook, the end of their program if it comes before then.
That's a great point, Anna. Definitely watching both of the clocks. Let's go to our next slide. So what happens if you reach the end of your I-94 clock?
So there's two different paths, right? You can either go abroad, apply for a new visa stamp, and of course you're going to need a new I-20 to reflect why you're returning to the US in F1 status. There's obviously pros and cons to every approach. One, important consideration to keep in mind there is that if you're going abroad, a consular officer may ask particularized questions about your intent to return home at the conclusion of your stay. They may ask questions about why you're extending your F1 status. Presumably, you've been in the US for a few years. And so that could trigger more questions about, why you're seeking to extend your F1 status. If you're somebody who is from a country that is subject to extra scrutiny or certain, nationality-based restrictions, you need to be aware that, going to your home country consulate could trigger some additional issues when you travel there. The other way that you could do this is you could file an I-539 with USCIS, which is what we've spent a substantial amount of time discussing here. And in order to do that, of course, you're going to need a new I-20, and other supporting documentation to show why you intend to extend your F1 status in the US.
And even before you do that, Tejas, that's just kind of to continue along the same lines, you have to show some compelling or medical circumstances to have to extend your program. And there are kind of two tiers of adjudication here. First, you apply to your DSO because they have to make a recommendation. They have to generate a new I-20 with which you will have to apply. And then, the second kind of stage in the adjudication process is going to depend on whether USCIS is going to find the circumstances sufficient. What is going to be compelling in this category. And, compelling or medical reasons or circumstances beyond the student control is something that we're already familiar with. It's something that DSOs use to decide whether to approve a reduced course load, for example. So it's very similar to the same type of thing, but now USCIS is going to, make a final decision. I also wanted to say that this is probably going to be primary evidence. So we're all familiar with the new RFE issuance policy change, right? What that was announced just maybe a week ago or a couple of weeks ago, where USCIS says that, well, we don't have to issue an RFE if we find that, you did not submit sufficient primary evidence. So is it going to be primary evidence? Is it something, that we need to worry about when sending it to or applying to USCIS? So a lot, and you're very right, there are pros and cons for each option, but, you kind of have to think about, also filing a Form 539 is not just filing a Form 539. There is a lot that, is going to decide the outcome of the case that depends on a lot more evidence now and a kind of a heightened, vetting process for that
That's
matter. So
Yeah, no, totally agree, Anna. That's a great point. And I have particular concern for individuals who may not be able to complete their program within the intended, time period. I think there's language in the regulation that basically says that, something along the lines of, we pretty much expect you, if you're coming in for a 4-year program, to complete the program within 4 years. And I know we're going to look a little bit at extenuating circumstances, but academic difficulties, for example, probably not going to be something that will be sufficient, in most cases to get an approval from USCIS. And that's one of the biggest consequences of this change, right? Because instead of being able to have that conversation with the DSO where you could say, okay, here's what happened, and they can sort of give you some degree of authorization to do that, you're now going to be submitting this application, frankly, to a nameless, faceless bureaucrat at the agency and hoping for the best and waiting for a decision.
And subjecting it to officer discretion, which is not appealable.
Which we know that they're not exercising in a favorable way right now. Yeah.
All right, let's go to our next slide. Tejas, can you address what a student should carry with them? What should they be cautious about when they're traveling?
Yeah. I mean, I think we've spent some time talking about sort of what you need to be thinking about when you return to the US, right? Which is number one, pulling your I-94. So just want to reiterate that and recommend that everybody pay particular attention to that. But in terms of what you need to travel with, I don't know that the guidelines are fundamentally changing per se, right? Around what you bring, what you carry with you. If a student today were to say, hey, I'm going back home for a week, what should I carry with me? My recommendations will depend on precisely where they are in their F1 life cycle, right? If they're in the midst of their course of study, I'd be telling them to get an I-20, endorsed for travel from their university or college. Make sure your passport is valid for a sufficient period of time. Carry whatever paperwork that you believe is going to help establish if CBP has questions to demonstrate that you're maintaining F1 status. Reminder for everybody about the fact that CBP and the consulates have the authority to sort of do extensive social media vetting. If you're somebody who's in OPT or STEM OPT, I'd be recommending that they carry their EAD with them, as well as proof of a valid employment opportunity in the United States. So those guidelines, I think, are going to be substantially similar. And of course, it's a slightly different, set of rules if you're going to be going to the consulate, and applying for a new visa stamp because maybe your visa stamp has expired.
That's true. So when the student is coming in and the CBP officer is going to sit there and review their documents, do they have to have original signatures? Should we help? I mean, I just think about all the mistakes CBP officers have on other categories on their I-94, calculating TNs, right? So who's going to help them out here? How are we going to figure
Yeah,
out for these students?
yeah. I mean, you're right. We see that sort of issue all the time with various types of work visas like TNs and L1s, where they're like, no, you needed to have two copies of this, not one, or, something else similar to that. I think it's always a good idea to make sure that you have original signatures on any of the documents that you need to carry with you. And think about ways that you can sort of bolster and supplement whatever you're carrying, in case there are questions. I know some students will even go to the point of trying to, structure their travel so they're arriving during normal US business hours so that if a CBP officer has questions, and is willing to contact the university, that there would be somebody at the DSO office available to answer those questions. So yeah, I think also just keep in mind that CBP guidelines are constantly changing. And so it's always a good idea to just make sure that you're trying to stay abreast of current information and consulting with your university before you travel.
Also, every time you re-enter, you should look up your I-94 and make sure it's correct. At cbp.gov, you go to I-94 lookup, you put in your information and make sure that it is accurate. If there's any mistakes, you should go to a deferred inspection site, which is all around the country, depending on where you live. Can we go to the next slide? Anna, could you address this with your DSO background?
for been a while since I was a DSO, but I think that the issues, some of the issues are, really the same and some are very different. Okay, so what are changing in the kind of the academic, with regard to the academic mobility, of students? So there are a couple of different rules, one for below graduate level students and one for graduate and above. And the rule specifically refers to below graduate level because we shouldn't consider this to be, exclusively undergraduate students, right? Because we also have ESL students, we have associate degree students. They all kind of below graduate level, and graduate level is masters, JDs, and all above PhDs, all of those degrees. So the below graduate level students are, the rules are less restrictive towards this group of students. The most kind of important
I just
restriction.
wanted to pause you real quick. Can we flip to the slides at 12 and 13? Just because we're already at 9:43, to make sure we get to some of the questions. Okay, go ahead. Sorry, Anna.
All right, so should I continue on that slide?
No, let's
That
just,
I
yeah.
Okay.
We'll
I
send
just
the
wanted
slides
to,
to
like,
everyone.
this is, very important, distinction between below graduate level and graduate level. So the below graduate level, during the first academic year, students generally may not transfer or change their major or educational level unless SABP approves the an extenuating circumstances exception, not to confuse with compelling and medical reasons, that we discussed. But extenuating circumstances exception is going to be adjudicated by SABP. For graduate level and above, changes in major or educational level are generally barred during the entire program. Okay, transfers generally require that SAVP approves extenuating circumstances exception. There are lots of questions here. What constitutes, an educational objective? What constitutes extenuating circumstances? So all of those kind of, terms of art are not well defined in the rule, so it remains to be seen how exactly that's going to apply. But, for example, students may change their campus within the same school, and that would not be a transfer. But then the question is, can graduate students follow their advisor if they went to a different school and work there? Like, is it going to qualify as and constitute as an extenuating circumstance? So that kind of remains to be seen.
Let's go to slide 11, which is talking about what Anna's talking about. Oh, yes, thank you.
Oh, okay, good. So school closure, loss of SAVP authorization, program elimination, comparable emergency, that is something that is pretty much well settled, that will constitute an extenuating circumstance. But there are so many cases of kind of in the gray area that we simply don't know about, and based on which the student may be forced to make an academic decision before they know whether they even need permission or if the permission is going to be given if needed. So yes, I already mentioned advisor relocation to a different campus, loss of funding of, the research. It cannot go on without sufficient funding. What about discrimination on campus or medical relocation for somebody who wants to, go to a school that's closer to a medical center, for example, where they want to receive medical treatment, and
Well,
change
one,
research?
one
Yes. Okay.
Sorry. One question that came in on the chat from an academic institution was there was a 4-year program. What happens if a student graduates early, like in 3 semesters instead of 4 semesters, and they want to be eligible for OPT? How does this affect? Like when do they apply for an extension? If they what how does early graduation affect this timeline?
So that's a very good question. And I believe that the question is about the kind of mismatch between the new updated I-20 for early graduation and the I-94 that lasts longer. The
Mhm.
rule actually addresses this point. So what the rule says is that you should assume that your status expires under the new rule the date of the completion of your degree plus 30 days, despite the fact that your I-94 can, extends into the future. So the validity of the I-94 does not, it does not determine the
Mhm.
validity of your status. Okay, so that's similar if you think about it. H-1B worker, they have a 994 valid, but then they're laid off, right? So
Yeah.
what happens to their status? They're out of status, but they have an initially valid I-94. Same concept, I think, will apply in this situation.
So if they graduate early within 30 days, they should apply for their extension of status for OPT.
They should apply for OPT or extension of status or leave,
Mm.
or change of status if they're eligible for any other status.
Mala, can I just add one quick point to that specific example? I think that individual may think, well, I have all this time left, so I only need to apply for OPT. But again, because we're adding this new layer of an I-94 that's not valid for duration of status, it could be that, the approval of the OPT is going to take them, that period of the OPT is now going to take them beyond whatever that I-94 period is on their original admission to the United States. So that individual might still need to include an I-539 with their OPT request, the 765, even though the I-94 is still valid for another 11 months. So those are the types of issues that, students are now going to have to navigate, just given this change in rules.
Let's flip to our practical training since we have only 11 minutes left. Practical training, CPT, OPT. There we go. Tejas,
There
can
is
you
a
talk
lot to
about?
talk about.
Yeah,
Sorry.
there's a lot.
Yeah. We've touched upon this a little bit, but in essence, you're transitioning from a guideline where if you are subject to the new rules, and again, we've talked a little bit about students who have the transitional protections, in which case, you're not necessarily subject to the new rules. But if you're a student that is subject to the new rules and you're applying for OPT, you're going to have to now file an I-539, which is a specific form that allows you to request an extension of status in addition to the 765, which is the work authorization request. Now, be aware that the 765 under current rules is eligible for premium processing, meaning you can get an expedited decision. I believe that time frame is 30 business days if you're specifically applying for OPT. But the 539 does not appear to be eligible for expedited processing. So there's going to be a little bit of a mismatch that you need to be aware of in terms of how quickly those decisions might come through. STEM OPT is going to be similar. If you get a 1 year approval when you file your 539 along with your 765, your OPT request, you'll have to repeat the same process to apply for STEM OPT. But this time you will hopefully receive an I-539 that's valid or an extension of status that's valid for 2 years, along with your 2 year STEM OPT extension. CPT rules are not necessarily changing, other than the fact that you need to make sure that your I-94 remains valid. That's still going to be processed through the DSO. It's still going to be reflected on your I-20. And so the document that you will need to present to an employer as proof of work authorization is still going to be that I-20, demonstrating that you have CPT authorization along with a valid I-94.
Thank you, Tejas. Can you
And
skip 2 slides ahead? Thank you. Sorry, Anna, what were you saying?
I was going to say that CPT, just wanted to add one point. The new rule doesn't address CPT. It doesn't change CPT. You're absolutely right. What I think is going to make it subject to kind of higher scrutiny is the policy update that SABP sent out to all of the DSOs and schools maybe a couple of weeks ago that reminded them of their obligation to follow the rules and not to be very flexible with CPT. So I'm very curious to see how that's going to play out and what is going to be the case when the student comes to the DSO with the employer that they want to work with, or will the schools perhaps, offer employment through their, own programs. So that is something that I think is going to develop into something else. But CPT, as we know it, is probably not going to be approved, or it's not going to work the same way as it used to. So that's something that I'm very curious to see how it's going to play out.
Absolutely. So before our students make any decisions, can you walk us through these steps that they should consider?
Yeah,
Tejas?
absolutely. First, I think you want to make sure that you're in compliance with what your F1 guidelines are, right? If you're required to maintain a full course of study, you're doing that. If you're in your OPT period, you haven't accrued more than the allowable unemployment amount, things of that nature. Second, make sure that you're in valid status. I know we've hammered this about 100 times on this webinar, but pull that I-94 and make sure that that I-94 remains valid. Third, if you're looking at, some sort of change to your program, Anna mentioned this briefly, but is it a change that's going to be permitted? To recap what we discussed earlier, no transfers or changes in majors during your first year of undergrad, and no changes, period, during your master's degree program. So are you in a phase where you are allowed to, make those changes or to extend your program or something of that nature? And then second, while we've harped on the I-94 to some significant extent, don't forget about the I-20, right? We talked a little bit earlier with that example of an individual graduating in 3 or 3.5 years instead of 4 years. You still have to look at that I-20 because it's a little bit like an H-1B with that analogy that Anna used, right? Where, in order to be a valid H-1B individual in the US, you not only need to have a valid I-94, but you actually need to be sort of in maintaining that status through the activity that that status allows you to engage in. And so it's the same concept here with your I-20 or other similar document like a DS 2019 if you're on a J1.
That's great. Next slide. Anna,
So
can
this
you?
is,
Oh,
yeah,
sorry.
sorry, go
Go
ahead.
ahead, Anna.
So what are the trigger points? What are situations that will tell a student that you need to stop and you need to think about it. You need to consult with somebody, your DSO or an immigration attorney. So before international travel, it's no longer, just getting an I-20, traveling, coming back. Like, are you traveling between the programs? Are you traveling because you want to extend your program in lieu of applying for an extension, or you are traveling, in the middle of your study? So this is an important point to consider before you travel, before your I-94 expires. So are you going to miss an important deadline to file an extension or to file something else? Tejas was mentioned a very important point that sometimes, your I-94 is still valid, but if you apply for an extension, you're not going to get employment authorization for 240 days. But, if you file before the grace period, it's all close to the I-94, but the timing matters here. Before changing schools or majors, are you below graduate level, graduate or above? And are you permitted to do that? Before extending the program or applying for OPT or STEM OPT, before beginning another degree, is it at the same level? Are you prohibited from having, enrolling in the program at the same level or a lower level? Well, by the way, if you have a degree that was awarded before the rule went into effect, the rule doesn't apply. So you can still presumably get a degree at the same level or even lower level. But what happens when somebody gets a degree in H4 status, but after the rule goes into effect? My understanding is that you may still not be prohibited from getting a degree in F1 status at the same level. So all of this decision making, is based on a combination of factors. So even, even something like, should I change my status to F1 from H4? So that's not going to be as simple as, well, I just want to work on campus or do CPT. Is that will include another, consideration or a couple different considerations. So a lot of, events and situations that, will require a more kind of deeper understanding of the issues and more planning, for sure.
That's a very good point. Can we go to our last Q&A slide since we have 2 minutes left, just to kind of address some things generally and let our speakers give their final thoughts? You were talking about the mismatch, Anna, and when that happens, I think earlier. And also, Tejas, you touched on the CPT, STEM OPT, a lot of those issues. What are some of your final thoughts, especially because this new rule is so much in flux? We don't know, is it going into effect on 9/15? The litigation, some of the stuff. What advice do you give where we don't have so much certainty?
Yeah, I'm happy to jump. Yeah, I'm happy to jump in first. At a high level, what I'll say is that, look, I'm sort of screening a lot of the questions, and I think there's a ton of questions from folks on, if they're transitioning from one status to another as to whether that can be accomplished before September 15th. There's folks who are here in F1 status right now who are wondering about what might happen in 2030. I think we're probably all going to need to take a big pause on that second question because 4 years is a lifetime in the current environment with so much that could potentially change. We've reiterated that there is some possibility that the rule might not go into effect on September 15th. And so I think the important folks for, listeners in this webinar who are in F1 status is, really just make sure that you are trying to get good information from good sources about how this rule is evolving, whether it goes into effect. And frankly, what a new administration, if we end up seeing a new administration in 2029, might also do around these F1 regulations. So that would sort of be my final thought.
Thank you, Tejas. Anna?
I second everything Tejas just said. I would also add that, don't assume you understand what's in your best interests. Speak with the DSO first, and then speak with a knowledgeable immigration attorney because, and we skipped those slides where we wanted to kind of demonstrate how different rules may apply to the same situation and how they can be in agreement or they can there can be a mismatch of sorts. A lot of the decision making will need to be done kind of with a different understanding, and it's just become in front of our eyes much more complicated than it's ever been. So I think everybody should kind of take a deep breath and try to make sure they understand what their situation is, and then just they should ask for help to make a decision.
Thank you, Anna and Tejas. I just wanted to apologize that we weren't able to get to so much of the information that we had planned in the interest of time. There's just so much to unpack in this really quick 1 hour and so much to talk about with both Anna and Tejas. And a lot of the questions that we saw popping up are really case specific. So I would encourage, if your question was not answered, please reach out to an immigration professional because it's very case specific on your specific facts. But with that, thank you so much for joining us today. On behalf of all 4 organizations, SAJCO, SABA North America, SABA Foundation, and Murthy Law Firm, we appreciate your time and you coming out. And thank you so much. Have a great day.